So what does it mean to be subpoenaed by the debt collection attorney in your debt collection trial? Hello, my name is John Watts. I'm a consumer protection attorney in Alabama. And while it is not very common, if you have a lawyer representing you, you could be subpoenaed by the collection lawyer to show up at trial. So what does this mean? Well, it simply means you've got to be there. If you're not there, let's just say bad things happen, okay? So if you get a subpoena to be in court, you need to honor that subpoena or get your lawyer, if there's some reason to fight that subpoena, to fight it. But you don't need to ignore it because that'll have bad consequences. So typically this is done in terms of subpoenaing you because the collection lawyer wants you to be there to provide testimony, because oftentimes they don't have the evidence that their debt collector or their debt buyer actually owns the debt or that you owe a debt. And so they say, well, if I don't have the proof of that, maybe I can get the consumer to be there and I'll get the consumer to admit that they had the debt, and I'll trick the consumer into saying that we, the debt buyer, now own this debt. Well, obviously if you have your own lawyer, get with your lawyer about that. If we represent you, we'll certainly get you prepared for trial. This doesn't happen really anymore, but maybe for a year or so, we had certain collection law firms that would subpoena our clients to trial because they were convinced that was the magic bullet. Man, if we just subpoena, John's clients, Stan Herring's clients, then we'll be able to win these cases. Well, it didn't really work out for them. So we don't find that happening. Actually, I can't remember the last time a client was subpoenaed, but just understand that's the purpose, is to get you there, because maybe you'll get nervous and you'll insist on settling the case. Well, obviously we would get you ready so that would not happen. But they also think, well, maybe you can provide the evidence, because if you've not been properly prepared for trial, you may not understand the questions that are coming or what they're trying to get you to admit that you would have no way of knowing whether it's true or not. And just to give you an example, they'll say, admit that we, the plaintiff, own the debt. Well, how in the world would you know that? You had a Chase card and now here's Midland Funding 5 years later. How do you know if they bought the debt? Okay, you have no way of knowing that, but they'll try to trick you into that. So just be prepared for that if you get subpoenaed. So I hope this is helpful. If you don't have a lawyer and you want to chat with us about a collection case or really any consumer protection matter, just give us a call, 205-879-2447, or you can reach us through alabamaconsumer.com. That's our main consumer website. And I appreciate you watching this, and I will talk to you later. Okay, bye-bye.